whoever you have selected.
Apparently that's me,
No.
so I will start. I am an intellectual property specialist and an international IP specialist. So my comments relate solely to the interaction between investor-state dispute settlement and intellectual property, and there are 3 points on that that I'd like to emphasise. First, I am concerned about the potential impact of investor-state disputes over IP, which I think introduce a new and dangerous dynamic into IP disputes. I think private companies are much more likely to bring complaints in doubtful cases, and that could lead to an increase in international litigation around the area of IP. Second, for the reasons that I've outlined in my submission, I'm not convinced that the safeguards included in such chapters, for example, in the recent Korea Australia FTA, are going to prevent claims being brought. And third, in particular, the carve-out in the Korean FTA as it relates to expropriation that's designed to carve out IP, ironically could have the effect of bringing the entire IP chapter into international arbitration disputes. And that's a problem because it could, those chapters are very one-sided and it's not clear that the public interest would be appropriately furthered in that sort of dispute. So overall, I'm concerned about ISDS combined with detailed IP chapters. I think they're going to lead to more international litigation. I think they're a constraint on domestic policy making, and such disputes could lead to less scope to promote the public interest in IP.